So this is just We the People News, y'all. Alright, so you wonder when you go to court, and then you go to the Supreme Courts, and you wonder why these judges are saying, well, it's unconstitutional, but this, so therefore we're going to go ahead and go by this. Alright, like our rights of our Second Amendment, right? We have a right to not to be infringed upon. But what I'm getting at is the infringement part, right? And it's these people right here, okay, making rules and regulations and statutes that interfere in the Constitution and Second Amendment or any other Constitution. Your Fourth Amendment, like the EPA on your land. All right, well, no, they don't need a warrant. Well, because it's a corporation and they're not signing an oath. The reason why? These people right here, plus others, obviously. Okay? This is the reason why we have Fifth Amendment violations, Fourth Amendment violations by our federal government, by EPA, railroad commissions, all these entities. Why? Because they don't have to sign an oath of office. Okay? And these are the people that Congress gave power to and not taking responsibility for. And when you call Congress, well, that's not a good law. Or, well, wait a minute, it's not a law. Or, this is out of my hands. You have to talk to these people. Then you have to take them to courts. Most of us can't because we don't have the money because it's very, very expensive. And that's the reason why we are losing our rights. Number one, it's too expensive to go to the Supreme Courts. Number two, it is so hard to go into the Supreme Courts because they are limited. So, Congress gets to get by without being punished. And these people right here gets to get by violating your rights because they're not signing an oath. And they're outside of the scope of being punished from us and punished from Congress. These people right here. Okay? Now they have certain guidelines, but the guidelines still factor remains that when you've been harmed, they don't have to pay. And when you've been harmed, Congress don't have to pay. Why? Ask Hillary Clinton. I mean, she's the one who broke policies. We keep on saying some of these things are laws, but a lot of times it's just policies. And if we break a policy, let me give you a deal, right? DOT requirements, okay? It's a federal thing, right? But it's still enacted in all states because of commerce. If you got a logbook violation that you somehow or another managed on your logbook, right? Well, you broke a rule, not a law. Y'all, EPA comes out here and finds things wrong on your land. You broke a rule. You did not break a law. Okay? But because we're under the impression that we're under the corporations, because in generally what these things are started off supposed to be, corporations. But they extended the authority to we the people. And under our silence acquiescence and tacit agreeing to their terms and not knowing what's going on, like I said before, the IRS thing, right? They had their own separate court. Sit and think about that. Okay? Post office, their own separate court. And they're not tied to an oath. Just saying, y'all.
As long as there's evidence in the record that might suggest to a reasonable person that that is a good idea. As long as that's there, the agency can do it if it has legal authority. On the other hand, many times people put in evidence that suggests this isn't a good idea. And the agency needs to rebut that evidence or explain why they discount that evidence. And if they fail to do it, then there's not evidence in the record to support the decision. So in those two cases, if there's a procedural foul or if there's an evidentiary issue, what does the court do? Well, the court's only option is to remand the rule. We basically send it back to the agency and we say, try again. And the agency at that time has the ability to try to correct the errors that the court has identified, either by providing more procedures or by providing more substance. And then the whole thing starts again, and you go back to federal court and answer the same question. So these are very blunt tools, but in the most common case, what frequently happens is that the court doesn't say, no, you can never do this. It just says, you didn't do this well. And the question is whether the agency...
There we go, right? Courts giving broad leniencies. That way they can go back and figure out some other way that they can violate your Constitution. You're violating this Constitution. However, we're not saying you can't violate their Constitution. You just got to do it a different way to violate their Constitution, people.
He has the time or ability to go back through the entire process and try again. So now that I've provided a hopefully somewhat neutral explanation, I'm going to turn it over to the victims who have to deal with these court orders, and you can tell us your view of what happened when rules end up in court. Boris, you first.
Sure. I think, Judge, you provided not only a neutral but quite a complete explanation, and I think it's a good. It gives us a good understanding of why so many rules are just in a perennial state of ping pong between the executive branch and the judicial branch without ever coming into effect. Maybe the one thing I want to say is draw a bridge between your comments and the earlier part of our panel. Just because the courts come at the end of the process doesn't mean they don't have an effect on the beginning of the process. You might be asking yourself, well, Paul, Boris, they seem to have law degrees. Their job doesn't really seem to have anything to do with the law. It's some kind of a policy, cost-benefit analysis job. Well, what's law got to do with it? It turns out quite a bit, because a lot of the debate during the regulatory enactment process happens in the shadow of the courts, in the shadow of Article 3, of which we're all victims. Because a lot of the colloquy between OIRA and the agencies is about, well, you know, Mr. Secretary, are proposing this, but we're quite concerned that there's a lot of litigation risk in this proposal because doesn't align, in a most logical way with the text of the statute. Should we have another alternative that better aligns, at least for the public to comment on? Or alternatively, OIRA, because of feedback from the agencies, might, for policy...
Text to the statutes, policies. They're not even talking about law. They're talking about statutes and policies.
Reasons want to add another alternative for public to comment on. And we say, Madam Secretary, shall we add this alternative? The feedback we get is, well, there could be a lot of litigation risk with that alternative. So a lot of, in a way, a lot of these legal debates are substantive. In some ways, they're a proxy war for competing policy preferences. Paul?
Yeah, I agree with all that. What I'd add is that the legal discussion that Boris just mentioned itself happens within the broader context of presidential decision making. Right? So, a president very rarely wakes up in the middle of the night and says, "What I want to do tomorrow is put out a Clean Air Act regulation under Section 112E to regulate X." No, the president has broader political goals, right? And so, typically, and understandably, appropriately, the president or his immediate advisors will have a big policy idea, and they will say to the lawyers, "We'd like to do X or something like X. Can you tell us what are the ways to do that? What are the authorities that we have following the law that Congress has enacted to do this. And so the lawyers will come back with half a dozen or a dozen or more ideas not always, sometimes there's only one way to do something, sometimes there's no way to do something. But very often there are multiple means to kind of get in the same area, get at or near the objective of the president, by drawing on authorities from multiple agencies. So I think you see this with the vaccine executive order for President Biden.
Again, I want to just add and stress to this very much. It is hard for any government officials or anything in your life that does not have attorneys involved. I'm just saying, y'all.
Which invoke multiple authorities from multiple agencies, all to promote vaccination, without taking a position on the merits of that question. So the point is that while statutory law is a tremendously important constraint with respect to particular regulations, there are so many authorities the president can invoke that if one authority, if the law prohibits the use of one authority for an executive, there's often another authority available. Not always, but very often. There are multiple authorities in play. The other thing I'd add is, it can be, how many...
They can make a statute or code or something like that, and one authority may not be able to do it. However, there's another authority that may do it. So they pass something to another place that may go ahead and violate your rights.
Have you heard of the Administrative Procedure Act for this lunch? Well, I am blown away. That is a much higher ratio than one normally finds. It's really encouraging. Is the APA trending on Twitter these days? I'll explain the way I think about APA review briefly. Because there are some people who aren't deeply familiar with it. I expect in the room. So one way to think about what APA review is it's review for whether an agency acted for reasons. It isn't about whether the agency acted for this reason or that reason. The agency has wide discretion to choose among the reasons for action. But it does insist that the agency act for a reason. Right? The agency can't enact a regulation without a good reason for it. It can't enact any provision of the regulation without a good reason for it. So, as an example, the most famous APA review case of all time, beloved by Americans everywhere, is the State Farm case.
Let's go with that, okay? Like EPA. And it's just an example, y'all. They come to your property and they say, oh, that pond, do not let it drain. Why? Because we need mosquitoes. And if you let that pond dry up, we're going to charge you $50,000 per day. Because what? You broke a rule, y'all. And in the Constitution, we have a right to property. In the Constitution, it says, cannot enter without a warrant. But yet, EPA can enter without a warrant. Why? Because they're not law enforcement. It's a bypass law. These people are creating rules and regulations to bypass the Constitution and bypass the laws. And then you turn around and you try to fight this in the Supreme Court with no money. And they'll tell these people, or EPA, says, well, okay, well, you can't do it this way, so you need to come up with something else, and they will. Okay, you cannot let the pond dry up because there's ducks. Oh, well, in that case, well, that's constitutionally all right and acceptable. EPA has the power to say your pond is never to dry up because ducks come there and drink water. This is how our rights are being violated and stolen, by the way.
From the 80s. And there, the agency decided not to include an airbag safety requirement, and it didn't say why it decided not to include it. And the Supreme Court said, well, there may be very good reasons not to include this requirement, but you need to tell us what they are if there are such good reasons. It's a violation of the Administrative Procedure Act, the APA, to issue a provision in the regulation without a reason for it. And so, as you work with members of Congress trying to understand what really is at issue in APA litigation, really, very often the court is trying to figure out whether the agency had a decent reason for what it did. So.
Not lawful, just a reason. The court says, what reason do you have to violate people's Fourth Amendment rights? Oh, okay. Well, go ahead and violate their rights then.
And before we go to questions, I'll just close by tying both of what you two together said, because what you aptly put it for us, that all of this takes place in the shadow of the law, what the agencies are doing. And what that frequently means is that when there are disputes between agencies, these two gentlemen, Paul and Boris, were called upon to act as almost a judge when agencies, perhaps including the Department of Justice, would come before them and make an oral argument, for lack of a better term, as to why their proposal was both legal and politically, and by that I mean policy-wise, sound. And Paul and Boris would frequently have the final say over who gave the best argument. And cabinet general counsels were frequently involved in this. And that's why I tell my law clerks, a couple of whom are here today,
which one is the best results? Legal or statute?
I argued in front of the D.C. Circuit Court of Appeals when I was in private practice. But the most important oral arguments I ever gave were not in front of a judge, and they were not in a court. And Paul was judge over a couple of them. And I'm proud to say he ruled in favor in those there. So I did a good job.
Quite correct.
Very correct. But these guys play an important quasi-judicial role, unofficially, in what they do carrying out their duties. And that's important to keep in mind. We've talked enough. You've got questions.
Unofficially. Sit and think about that, y'all. Yes, it's in the Constitution these people are allowed to be here, but they're not allowed to have this much power over the people. They are allowed to have this much power over corporations, I guess is the best way of saying it, right? And I don't even think they're supposed to have that much power either. However, we're going to go back with the Second Amendment, right? It's these people right here that's helping in the contents that we've got to sign pieces of paper to get the blessings, permission to bear arms, and have our Second Amendment granted to us. Okay? But that's what the Supreme Court's going to look at, right? Well, what is the reason for this paper that they must sign? Oh, because we're trying to keep crime down, and we figured this is the best way. Oh, in that case, you can go ahead and violate the Second Amendment. Thank you, Supreme Courts.
We want to hear them.
All right. These We the People News. Bye, y'all.